great to be back involved with anything associated with family advocacy. I just thought I'll get straight into. I too would like to acknowledge the traditional owners. Here I'm in Sydney on the land of the Gadigal people of the Eora Nation, and pay my respects to any Aboriginal people here who are joining us as part of the meeting today, but to elders past and present and to emerging leaders. I want to just put guardianship and financial management into a very brief context, because I know the time is limited. But really, guardianship and financial management are examples of substitute decision-making, okay? And what that means really is in arriving at an informed decision, not a choice, an informed decision with an ability to weigh up the pros and cons of any particular option, take on board conflicting opinions or expert advice, and come to a decision. That's what we mean by informed decision making. Now, you know, there's the UNCRPD, of course, talks about substitute decision making, and the Australian government took that forward in 2014 in a large report that looked at what supported decision making look like in Australia. And that reflected a paradigm shift about saying that everybody had capacity. That's the starting point. And some people need support to exercise that capacity and to make a decision. And that important report brought in the notion of will and preferences as part of the decision-making process, because substitute decision-making is all about best interests, and as best interests are often defined by others, not necessarily by the person. So we need to understand where this fits at a particular kind of point in the continuum of decision making. And, you know, all the policy talks these days, but may well be variable in its implementation, about support for decision making. And that is understanding the nature of the decision. What assistance does a person need to understand that? What training do supporters need in order to help them to arrive at a decision? And that supporting decision making is, of course, at the heart of building the capacity of our sons and daughters and family members with a disability, or anyone with a disability, so that they are able to make or contribute to the making of decisions that reflect what they want for their lives. So that's the kind of context that I imagine through family advocacy and resourcing inclusive communities is all the discussion that you've had and material you are involved with, but this is at a pointed end. And it's good to understand. The other part of that kind of context in this are issues about enduring guardianship and enduring power of attorney. Now, these are instruments that all of us should be developing, that appoint decision makers, appoint people that we trust to make a range of decisions for us when or if we lose capacity. Now, just because a person has a disability or even has a cognitive impairment does not mean they would not be able to execute a enduring power of attorney or an enduring guardianship appointment. The key thing is, do they understand the intent and the effect of doing so? So let's break it down into real things. What it means, the intent, is that you're giving over the ability to make decisions. Let's take enduring guardianship, which is about lifestyle issues. And there's someone that you trust or a number of people you trust who you think will make good decisions about where you live, what health care, whether you have a particular medical treatment or not. You trust them and you develop a document that is overseen by a solicitor or through the local court that says that I entrust that decision making to someone, a particular named individual. Now, if you think about many people with an intellectual disability, with a cognitive impairment, they can, through discussion, capacity building, over a period of time, they will know who they want to make decisions. They will know who they trust. And if they are able to understand that in developing an enduring guardianship appointment, they're saying, I want my brother John, he treats me well. He's good for me. And they may not be articulating it as well as that, then they can, under a solicitor, develop an enduring guardianship appointment. Now, it is about, when I'm saying, all of this is about not choice, but informed decision. So when we're thinking about that question of enduring guardianship, can your son or daughter, can they understand that by making their brother the enduring guardian, they're going to say their brother can make those decisions? I trust them, etc. And that they will have that authority, that ability to do so. Then a solicitor can sign off that they have done due diligence to ensure that the person understood the intent and the effect, and they can develop an enduring guardian. Now, not every person who we're thinking about today in this meeting has that ability, but many people do, and it is important that they are supported to develop those kind of, long-standing appointments. Why? When you've made an enduring guardianship or enduring power of attorney appointments, they last. They go on forever. Okay? On the other hand, if you have a guardianship order, then that is time limited, usually 12 months in the first instance, and you have to go back and go, tell your story and meet the requirements of a tribunal. The other is ongoing. And through, in terms of siblings, for example, you can identify them as if at the outset the enduring guardianship is given to a parent, you can identify a sibling as one of the alternate guardians, or you can always go back to the tribunal to have a review and have a substitute name put in when parents no longer have that kind of capacity. So the beauty about an enduring guardianship or enduring power of attorney appointments is they are long-standing, okay? And you don't have to have government intervening in families' lives. Remembering, though, really stressing, it's not just about choice, but they need to be able to, the solicitor who will witness it needs to be able to have a basic conversation that ensures that this person is not being, misused in some way, giving authority over their life to somebody else. Okay, so these are, supported decision-making, enduring appointments, etc. All of these things, why do we think about it? We think about it about safeguards for people that we love and we care about. And we all know, though, that the best safeguards come from people in someone's life. And so, we're looking to develop mechanisms that the law or services or doctors will accept that says that somebody else is allowed to make decisions for a vulnerable person. Okay. So now I'm going to get on to really what are we talking about today? It's substitute decision making. Okay. And what that means in New South Wales, and these things vary from state to state and certainly from country to country, but guardianship is about lifestyle decisions, about decisions as against financial decisions, okay, for which there's financial management, and we'll come to that afterwards. Lifestyle decisions include things like where a person lives, the services they use, healthcare, which is the ability to exchange information and get information from health providers and share it with others, medical and consent to medical and dental treatment. They're the kind of main ones, but they can be anything. They can be about travel. They can be passport. They can be legal services. Anything that associates with lifestyle issues. But those main ones, accommodation services, healthcare, medical, and dental, tend to be the core of the decisions. And what I'm going to do now is I'm going to kind of run through the process that guardianship goes through, and then I'm going to look at what kinds of decisions. Guardianship, it's a stepped process. Each time there is a threshold that must be met under law that allows us to go down and cascade down. So the very first threshold is that of capacity. That is, does the person have a disability that impacts on their decision making? And that frames for us at the tribunal the question of, is this a person for whom we could make an order? Not we have to, but we could. Because if someone has capacity, we can't. That stops. Goodbye. Sorry. It's not within the jurisdiction of the tribunal, and people have a right to make bad decisions. At the tribunal, you get plenty of applications on behalf of people where you can see why they're making some pretty awful decisions for themselves. But if they have capacity, that's their right. Okay. Now, that determination, that decision about does someone have capacity, it's not got anything to do with IQ or, in many of the people that come through our tribunal are elderly, and you'll get different screening mechanisms where it is quite clear that somebody would be unable to weigh up the pros and cons of different options to come to an informed decision. Often that's quite clear. For people where it's unclear, but someone wants them to have a guardianship order and they think, no, I don't want one. Things like a neuropsychological assessment are often sought, and that is by a particular branch of psychology that have a whole lot of tests that look at those thinking areas, and whether a person has the ability to retain information, process it, use it, and the like. Okay, so that is about determining capacity. But just because someone's got an intellectual disability does not mean that they automatically ought to have a guardian. And as we say to people, so that's the first threshold. Is this a person for whom we could make a guardianship order? But the very, 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 very vast majority of people with a decision-making disability in New South Wales do not have guardians. Okay, why is that? It's because there's further steps. Our next question is, should the tribunal make an order? And the answer is that there is a need if the person is objecting to the kind of decision that everybody thinks is in their best interest. So, a typical scenario, not, that you'll be able to see, your elderly person that's got dementia, they've had a fall, they've broken their hip, they're in hospital, there's a decision about where they're going to leave after hospital. They lack insight. Oh, no, I can still do everything I used to do, but unfortunately they can't, and they can't even see that they, etc. But they say, I'm not going to a, nursing home. I'm not going anywhere other than home. So they're objecting to the kind of decisions most people think they need. Okay, so informal mechanisms can't work where someone objects. Another reason a formal order might be needed is that you've got some block to informal decision making. Because what I should have said is that the tribunal, under the legislation, informal decision making is always preferred. If there are people who have a longer relationship and thinking about the person's best interest, the informal mechanisms must be used. That people don't want governments imposing on the lives of people with decision-making disability. But for many people, there are blockages. Sometimes it's at the hospital, although there is a mechanism, and I'll come to that, for those person responsible, but sometimes you'll get bloody-minded doctors and hospitals. Sometimes you'll get service providers. Unfortunately, I'm sure everyone on the call is used to blockages in many avenues, so I probably don't have to. But if there's a blockage, a formal order might be necessary to open the doors. And the other area where a formal decision maker is needed is when there's conflict. And unfortunately, in many circumstances, there is different views within the family about what is the decision. And so it needs to be formalized through an order. Okay, so we've got, is this a person for whom we could, when we looked at the capacity? Should we make an order? And there's some of the reasons why, the informal mechanisms aren't working, aren't able to work. And so, we should make an order. That would be in the person's best interest, having clear decision making. And then it becomes a question in New South Wales about what decisions, because, it's not, we hear Britney Spears and her father had, years worth of guardianship over all areas of her life. Well, that could never happen in New South Wales, because the only areas that are considered that you can make, you only make orders over the specific decisions for which there is blockages and you're unable. So, as I said, the main ones are things like accommodation, services, healthcare, medical and dental consents. Okay. So what areas? So the tribunal may seek to make an order over accommodation and services, because the healthcare, medical and dental can all be done informally. So there. And then there's a question of who is a suitable decision maker. So you've got, we could, we should, these are the areas we might. And then we come to who. And under the legislation, the tribunal must always prefer a private person if a suitable person exists. So suitable is, pretty broad, but do they have a compatible personality? Because one of the key things, whether it be in whatever area, enduring guardianship or as a formally appointed guardian, the first step is to see and listen to what the person with disability wants. What's their views? That's critical. That has to be at the heart of it. But a guardian or an enduring guardian must also look at what other people whose views are valuable, are informed, can contribute to that decision maker. So it might be other family members, it may be health professionals, it may be service providers. It's not defined. Okay, but that consultation with the person with disability is at the heart and is step number one, etc. So that's the kind of question about compatibility. Will the person who is putting themselves forward as a guardian be able to talk to hear from the person and to understand their views, as well as their ability to listen to others and the like? So that's the question of who. And then the final question is, for how long should the order last? So they're not forever in general, unless there's, special circumstances. The first order is only for up to 12 months, can be 3 months, can be 6 months, up to 12 months. So that, what is the time frame? The question we ask is, what decisions are likely to come up in the next 6 to 12 months? This is not the just in case, when I die, who's going to, etc. At the, an application for a guardianship order can be made at any time, and you can do it frequently if you needed to, if circumstances changed, etc. But what is the likely time frame in which those kinds of decisions are going to be made? And after that, the order is reviewed after the 12 months or 3 months or whatever it is. The order is reviewed to see whether it's still necessary or it should be varied. When we come to the kind of decisions, going back to that for, a bit, in real terms. So one of the key areas is often accommodation, where a person should live. Now, I imagine for everyone on the phone call here today, the accommodation is funded by the NDIS. So that's actually, if a person is the NDIS nominee, they are already the formally recognised decision-making, because the accommodation is a service under the NDIS. Where it has greater import is, for example, whether someone, more in a context of older people, living at home or in supported living or something like that. But, the ability to move out of home and, into a home of your own, or even into, a SIL arrangement or something like that. They are, if you're the NDIS nominee and the person is not objecting, then whoever that is, that nominee already has that decision-making authority. Services, well, that's your NDIS nominee. Healthcare. The issue about healthcare, medical and dental consents, under the under the NCAT guardianship legislation, there is a status called a person responsible. Once upon a time, it was thought of as the next of kin. And that is a person that has an enduring relationship with the subject person, the person with the disability, and they are the natural one to make decisions. And so often, even if someone does need, for example, a formally appointed guardian in relation to accommodation and services, they may well be able to continue to do those healthcare, medical and dental informally. And the tribunal would be reluctant to add those functions if they can continue to be undertaken informally. Now, there are some areas where an order is necessary. Okay, one is restricted practices. And, that's by legislation. So if in the way in which, in the context of a behaviour support plan, an NDIS participant has some strategies that are used to control behaviour. Might be environmental, so there might be some locked doors or gates, or reduced access to the fridge, things like that, or reduced access or elimination of sharps, knives, and things like that. That is an environmental restraint. Some people with disability are assisted to be calmer in their day-to-day lives, and there's medication, chemical restraint that is used. And so any kind of restrictive practice needs to have a formally appointed decision maker, and irrespective of the effectiveness of any other area of informal decision making. So that's restricted practice. Another area in which a formally appointed decision maker is required is a function called authorize others. So if a person, I'll give you an example, kind of the elderly person in hospital that is going to have some respite at a nursing home, they'll try and use an ambulance to transport the person to the nursing home. And if, when the ambulance comes, the person says to the ambulance attendants, no, I'm not going anywhere other than home. I'm not going. The ambulance will not take them unless the guardian has this additional function of authorize others, which allows the ambulance or the police to take a person to a place, to hold them there, and to return them should they leave. So it's a very particular, and these additional authorities are only given through the tribunal where the applicants, where the people who are asking for the order make a very specific case. It's not given out willy-nilly, because they are serious infringements of someone's rights, but can be enabling when, a particular action is required, but the person who lacks insight into why that action's required is objecting to it. And the third area where a formally appointed decision maker is required is in something that's called override objections to medical treatment. Now, some people need to take medications for mental health things, for physical health things, and they refuse. Not that, it's not, when some people have difficulty swallowing and kind of it's a bit uncomfortable and those sorts of things. That's not an objection, that's a physical difficulty, and so doesn't get covered. But where they say absolutely not, or they spit it out and those sorts of things, sometimes it's in the person's best interest to have that medication crushed up in their ice cream, in their hot chocolate, whatever it is. So it's concealed. And if you're going to conceal medication, then you need to have the authority to override objections to medical treatment. So there are three areas where, irrespective of how effective other informal decision-making mechanisms are happening, an order's needed. I noticed the time. I apologise. It's taking a little bit. I'd like to move on to financial management now, because I know many people had many questions about the question about, being able to control your family members, to make purchases and to make payments on behalf of your family member. Now, the need for financial management has increased astronomically since the Banking Royal Commission. And the banks absolutely had many, many things to answer for, and, safeguards around people need to be put in place. But, really, sometimes they're very, very difficult institutions. And people who have set up bank accounts prior to their family member turning 18 and things have gone well and they're they've got full visibility and through internet banking they can do whatever's required, etc. Something happens like the card, you need a new card, and the bank goes, no, you can't do this without a financial management order. And in some cases, they will stop it from one day to the next. Sometimes we've got experience that they say, by June 30th, you need to have become a financial manager. Otherwise, we block access. Some banks refuse to set up bank accounts. A bit of shopping around there is often helpful, but not always. And it might only be helpful in what turns out to be the short term because banks are requiring this additional safeguard, which can be rather cumbersome. So if your family member can, in some ways that the enduring power of attorney is an easy thing for them to easier. It's not complicated. Do you trust your brother John to look after your money? Make sure it's used only for things that benefit you, Then an enduring power of attorney instrument can be executed. And that's kind of an easy way. I mean, it's all about, do you trust the person? Is it when that's not possible and you're required to make a financial management application? The thing about, once again, private people are preferred, and you can have a couple of people appointed jointly and severally, and that means that, that's two people who can divvy up the tasks, or one person is away or unwell or something like that. There's still someone who can it's not help to manage the money, who can manage the money. That's the whole thing about this guardianship and financial management. It's euphemistic to say, can I help you to make this decision? Because ultimately it is a substitute decision and the person who has been appointed has authority to do it. Best practice is, without any shadow of a doubt, is you talk to the person and you're implementing their wishes, but the kind of legal decision is you have the authority to do it. And so, it's a question of trust. If you need to go down the road of being appointed a private financial manager, any private financial manager works under the directions and authorities of the New South Wales Trustee and Guardian, which is the government body. So there's that, if there's no one suitable in a private capacity, the financial manager does become the New South Wales Trustee and Guardian. When you do it under, and they charge fees, if a person's income is straightforward, probably just the pension, those fees are kind of more or less nothing. If that person has some assets, then there's a percentage of that is taken. When a private financial manager is working under the directions and authorities of the New South Wales Trustee and Guardian, it means, number one, before you get started, and the trustee and guardian give the private manager information and forms to use, the financial manager has to develop a plan to show how they're going to use that money. And at the end of the year, they have to account for how they've used it. And it doesn't mean often, you provide the bank statements and that's enough of a record. They don't need the breakdown for every cup of coffee. But that's a requirement. And if you don't provide those reports over a couple of years, then the trustee and guardian will bring it back to the tribunal and ask for it to be reviewed and for them to be put in. And that's about a safeguard. It's onerous, but that's about making sure that the financial manager is using the money for best purposes. And I can tell you, at the tribunal, we see plenty of examples where they're not. Unfortunately, that is the case, and that's why the kind of supervision is there both for the financial manager so that there's transparency, and accountable to the person about the use of their money. And I know one of the questions was, if you don't end up, if you can continue to do things informally, how can you be transparent and in good faith? And my answer to that is keep accounts so that they can be shown to anybody, at any time how you've used the money. Not by the $5 coffee, but accounting for the vast majority of the way in which the money has been used. I hope that kind of gives an overview about this area of substitute decision making. One final kind of exhortation is that we all should develop enduring power of attorney and enduring guardianship instruments for ourselves, because it will give clarity in the future as to who you trust to make what decisions. And you need to, of course, talk to whoever you're appointing and make sure they understand your intentions, your wishes, and you need to make sure you trust them.